Good morning, Honorable Chair and members. I'm happy to be here to introduce SB 1146, which addresses the protection of victims from the egregious harassment of incarcerated individuals. These silent victims suffer emotional trauma and live in constant fear of something we all take for granted, the mail. These victims filed restraining orders or received protective orders through the courts against the incarcerated expecting protection. This bill was inspired by a recent case whereas an individual was in custody on a case for stalking. Despite a protective order, this individual sent multiple letters, cards, and notes to the victim while in custody. The DA's office was forced to just note the action. So despite the protective order, these forms of communication could not be intercepted and the DA's office could not seek punishment for breaking the protective order. The victim was forced to constantly undergo the emotional trauma of seeing those communications each time they checked their mail. A protective order under existing law prohibits the contact of an individual via mail, verbal, nonverbal, or electronic means. The penalty for breaking a protective order is a $1,000 fine leading up to 1 year in county jail. Under current law, the penalty for breaking a protective order or restraining order has little or no effect on an incarcerated individual, as seen in the example shown. SB 1146 seeks to give victims that layer of protection from incarcerated individuals by allowing the prison authorities to inspect outgoing mail for the purpose of enforcing a restraining order or protective order against an inmate. Under current law, if an inmate sends a letter to an individual who has a restraining order against them, the victim can do the following. The victim can report the action and hope that the district attorney can file new charges against the inmate, which we are seeing is not happening. The victim can submit a written complaint to CDCR administrative officials who can consider the situation, if approved, may stop the future mail. All this time, the victim is suffering from the emotional trauma of receiving the mail from the inmate. To summarize, SB 1146 is a very narrowly focused and simple bill that gives authority to enforce protective orders and restraining orders in both jails and prisons when the mail of each inmate is already searched before being sent out. SB 1146 has received unanimous support in the Senate Public Safety Committee and on the floor of the Senate and zero opposition. Let's give the same protection to those victims who already have suffered enough. Appreciate your consideration. Thank you, Mr. Chairman.
Thank you.
Morning, Mr. Chair. Ryan Sherman with the Riverside Sheriff's Association. Our members are pleased to support the bill. This bill would allow state and local law enforcement to limit the ability of incarcerated persons to harass victims who have obtained a restraining order. As the Senator said, although existing law prohibits a restrained person from communicating with the protected individual, it provides no mechanism to prevent these types of illicit communications. Additionally, current law is also silent on whether jail and prison officials may lawfully intercept these illegal and harassing letters. This results in these victims being forced to endure constant emotional trauma with no hope of relief. SB 1146 establishes a simple yet effective means to facilitate the enforcement of a court-ordered restraining or protective order against the inmate by granting corrections officials the authority to inspect outgoing mail from incarcerated and restrained persons. Riverside Sheriff's Association appreciates this bill, and we ask for your aye vote. Thank you.
Thank you. Are there any other witnesses in support?
Good morning. Christine Ward, Crime Victims Action Alliance and Citizens for Law and Order and Support. Thank you.
Thank you. Are there any witnesses in opposition? All right. Seeing none, are there any questions from committee members? Seeing none, you may close.
Mr. Chairman, I respectfully ask for an aye vote.
So I think the challenge that I have is that you can get a restraining order, and I know this sounds oversimplistic, but if someone were to receive a letter, I think it's well marked that it's from a correctional institution. They can just merely throw it in the trash. And so I'm not, the challenge I have with doing something that in some ways are kind of redundant, and I don't like, as a chair, I don't like this committee to over prescribe or over write the same laws over and over again. And that's, my opposition is not to the idea of protecting individuals on the other side, but I do believe they already have the existing protections that they need to have, and that they can implement. And so I haven't seen the need, and whether or not it's a different discussion, that we have a discussion about ways we can better empower individuals outside. And it's not just women, but there are probably men that can be harassed and part of the prison culture have difficulties. There's things we can do to empower them so that they don't have to deal with that. And so that's part of my no, and if we can work out something internally or with and whether or not CDCR can handle this new responsibility, we'd like to have that discussion. And so unfortunately, I'm going to recommend a no, but I would like to, and if it doesn't pass, I would like to continue the conversation, because I do believe you're absolutely right. We need to empower the victims more so that they, not only that they know of their tools, that they'll have the tools that they need to better protect themselves. And the other part is making sure that CDCR can actually implement all of this. And with that, the chair is recommending a no vote right now. Madam Chair, call the roll.
SB 1146, the motion is due pass. Jones Sawyer.
No.
Jones Sawyer, no. Lackey. Lackey, aye. Carrillo. Carrillo, no. McCarty. Kylie. Kylie, aye. Quirk.
No.
Quirk, no. Weber. Weber, no.
I'm sorry, that measure fails, but please come back
Ask for
to my
reconsideration.
office. Yeah, come back to my office. Well, without objection. Okay. We've got to grant unanimous reconsideration.
Thank you, Mr. Chair.